Many legal experts make videos based on judgments of high courts and Supreme Courts. It looks like as a final and simple solution has come for any cheque-bounce accused to win the case. To take benefit of such judgments, the first thing the accused do is to admit the documents of the complaint. Visit any court anywhere in India, and 90% plus conviction of the accused is due to such admissions. We will discuss in detail here why it happens. How the accused gets trapped in losing the case by his own defense. First, please note that as per Article 141 of Constitution, only ratio discendere judgments are binding on lower courts. To judge judgments of Supreme Court or single-judge High Court judgments are not binding. They are referred as passing reference based on particular case and are called obiter dicta. The cheque-bounce law is based on documents of the complainant. Law has given presumption under Section 118 and 138 of the law to the documents. So when accused admits documents, the liability of the accused is presumed. The provision of power of rebut to defense is most misunderstood. Most of the accused and legal experts believe that as per normal criminal law based on presumption of facts, the complainant has to prove his case. It is not the legal position. On the other hand, the cheque law has given presumption to documents. So the complainant has to just prove the documents. Most of the times, accused on first appearance or replies thereafter admits the documents of the complaint and makes the job of complainant easy to prove his complaint. To rebut the presumption of law, the accused has to produce evidence and not arguments or story, which most of the accused do or legal experts suggest. Again, while making defense based on obiter dicta judgments, the accused should remember that there are many specific ratio discendere judgments of Supreme Court for cheque law, and the two bench judgments of Supreme Court or judgments of high courts cannot overrule such judgments. Rangappa 2010 is 3-judge Supreme Court judgment, and Supreme Court 2021 5-judge Constitutional Bench judgment in cheque matters are reference ratio discendere judgments and are binding on all cheque cases in all courts. Many times two bench judgments of Supreme Court or single-judge High Court judgments may look like against the reference judgments, but such judgments cannot overrule 3-judge judgments of Supreme Court. Such judgment have come after specific evidence in particular cases and are obiter dicta judgments and are not binding on other cases in any court. Simple examples is in Baslingappa judgments. The Supreme Court has said that the complainant did not have financial capacity, so released the accused. But in this case, the accused had proved by hard evidence in the court that the complainant did not have financial capacity. So is SC 2023 Raza Raman case. Legal experts and accused do not read these judgments fully and properly and take the defense that the complainant has to prove his financial capacity. So whenever the accused takes defense based on various judgments without going through the whole history of judgments in particular issue, since obiter dicta judgments are not binding on other cases, and hence get trapped in taking wrong defense, the first thing he does in such situation is that he admits documents of the complaint and make it easier for the courts to give conviction. Visit any court anywhere in India, and 90% plus conviction is given by the courts to the accused due to such admissions. Still, cheque complaints have many technical defects, and accused can win the case on such defects. But after proper scrutiny, the defects have to be pinpointed legally with specific provisions of law, then only success is possible. There are many such legal defects which we will discuss in next episodes one by one. Every case has a specific story and hence specific technical defense. By technical defense, any cheque-bounce case can be won. Since in most the complaints there are mistakes in pleadings and documents. Our legal team prepares step-by-step defense after scrutiny of the complaint in minute details for the accused and so that he can win the case legally and easily. We conduct the cheque cases in various courts and have experience of effective legal steps and not just bookish knowledge. There is legal proper defense against the application under Section 143 is equal to A for initial deposit application of the complainant. The law in this matter is not mandatory, therefore without proper reasons any order under Section 143A is not legal. We prepare proper defense so that the accused can come out of any such situation. Please send all the documents by email and hard copy by post. Our legal team will study all the aspects of the complaint and will give step-by-step procedure to contest the case and come out of it easily. Even if you have lost the case in trial court, there are good possibilities to win an appeal by legal defense. Hard work has to be done to properly study the mistakes made by the complainant in trial court. Most of the accused and their legal experts do the mistake of repeating the defense of trial court and fail miserably. In appeal, first the accused has to apply for redrafting of appeal memo to make it more simple and legal. Accused can also apply for further cross-examination of the complainant. By proper leading questions and by further cross-complaint can be proved wrong. At appeal stage, the accused has to take effective expert legal steps, otherwise, if the case is lost here, there is no bail. High Court does not grant bail immediately and heavy deposits have to be made at the stage of hearing. We give complete legal guidance for conduct of appeal with fair chances to win. First, send all the documents by email and followed by hard copies by post. Our legal team will study the whole case and will outline steps to conduct the appeal proceedings. Our legal team actually walks in various courts and just do not give bookish advice. We know how to take proper legal steps in court effectively to bring results. Please subscribe and watch this channel regularly and share with the friends facing similar problems. We discuss various provisions of cheque law with reference to latest judgments of the higher courts regularly in this channel.